Hey guys, so this week I decided to do my post on discrimination driving under the influence and a little backstory. Mary Martin, a female tenured teacher in a rural conservative district, was stopped by the local police and charged with driving under the influence. She explained to the police that she had just left a Christmas party given by her principal and that she had consumed only a few glasses of wine. She was also aware that some of her male colleagues had been stopped in the past but not charged. Nevertheless, she was still charged. As her arrest becomes public, there is pressure from the school board for her to resign. So one of the first questions was, can the board force Martin to resign? And I just stated, although teachers have certain freedoms, they are held to a higher standard in the eye of the public. Miss Martin did break a law that not only endangered her life, but the lives of others. And unfortunately, her arrest was made known to the public, and it seems to be disruptive to the school system. So since Miss Martin is a tenured teacher, I feel that in this instance, the Board of Education could request her resignation. Or if it gets to a point where it gets out of hand, they could actually terminate her. Depending on the county or in a more lenient school district, she could possibly be put on a probationary period at school. Is the infraction serious enough to warrant dismissal? I said, if Miss Martin has gone to court and has been found guilty with the charge of a DUI, then I feel the infraction is serious enough for dismissal. However, because of the presumption test, people are presumed innocent until proven guilty. So if her charges are dropped or reduced from a felony at her court date, then Miss Martin should be able to keep her job. But again, it depends on the county or the school district whether or not dismissal or a probationary period would be considered for her. But I really feel that those are the two choices that the school board could make or her principal could make. As far as the male colleagues who are not charged for the similar offenses, I feel like it serves no purpose. It's kind of like hearsay. It's a he said, she said type of thing. She was pulled over and she was found to be driving under the influence, so it doesn't matter at this point as far as the police goes. It's not actually an educational thing. She's not at school. She's not dealing with that. There's no evidence that even her male colleagues were breathalyzed or charged with driving under the influence, although she was, and then arrested for committing the crime that she knew was wrong. What rights does Miss Martin have as a teacher in this situation? She has the presumption test, which will be extremely helpful in her case. If she hasn't gone to court yet, there's a possibility that she's innocent of her crime, and the charges could be lessened or dropped depending on how severe her charge was, the lawyer that she hires, or the judge that presides over the case. She could possibly bring up the fact that the male colleagues were not charged for similar offenses using her rights from Title VII. However, it states in our book on page 225 that to succeed under Title VII, a plaintiff must demonstrate that the employer's reasons for the challenged employment decision are false and that the actual reason is discrimination. This burden often is difficult to prove because in very few instances do plaintiffs have objective evidence or proof of discrimination. And I feel that Ms. Martin really doesn't have proof since the other colleagues weren't charged. The school board hasn't had to deal with this situation. What factors would the court consider in ruling on her case, and what conclusion do you think the court would reach in this situation? So I said that I think the court would consider other DUI cases in the school district and what consequences were given to those teachers. I also think the court would factor in whether or not Miss Martin was found guilty in court when she finally went to her court date. I also think that the school board provides I feel that if the school board provides evidence that Ms. Martin committed a crime and takes the legal necessary steps when asking for her resignation, there shouldn't be a legal problem. So school districts will not be supported by the courts when there is evidence that districts discriminated against employees on the basis of race, color, religion, gender, or national origin. However, in this case, Ms. Martin committed a crime. She was charged and arrested for driving under the influence, and I think the courts would rule in favor of the school board's decision.